Welcome to the sixth FCC Open Internet Roundtable here at the Commission. I've just got a couple of very quick housekeeping notes before we get started. First, please note the location of the exits in case of an emergency. Second, this proceeding is being streamed live at fcc.gov/live. We encourage everyone, both in person and watching on the internet, to submit their questions using the email box roundtables@fcc.gov or on Twitter using the hashtag FCCRoundtables. We're scheduled to break here at about 11:15, and then again we'll go until 1 p.m. And with that, it's my pleasure to introduce Chairman Tom Wheeler.
Thank you very much, Eric. And Eric reminds us all that really who we ought to be thankful for are people like Eric, who has been the behind-the-scenes, how do you put everything together guy on these roundtables we've been having. And also I want to, focus on some others. I don't see Roger Goldblatt here, but Roger was key in working with the various groups. Betty Lockhart of CGB. Don't see her. Everybody they get recognized, but they're not here for their recognition. I mean, I don't know, but Keila Hernandez Uola is also of CGB. There she is, back in the corner. Keila, thank you. Jeff Reardon is hiding back in there, and Steve Balderson is back in there as well, because they're the folks who allow this to be seen literally around the world. I don't know how many of you were watching the last episode, but there was literally a question that came in from New Zealand. But there have been questions from all over the country that have come in, and that's my chance to do a commercial here. To say that to all of you who are listening out there on the web, I mean, the powerful thing here is that we may be located physically here, but everything is happening out there in the web, in the open activities, in the open marketplace that's represented by the internet. And we encourage those of you who are out there to submit questions to roundtables@fcc.gov. There it is on the screen if you're emailing, or by Twitter at hashtag FCCRoundtables. This is the last of the and the sixth of the Open Internet Roundtables. That at the beginning I said I hope that we are in an effort to turn heat into light, and I look forward to today's session for the same kind of purpose and goal. This is not a monochromatic topic, but it's one that we need to make sure all viewpoints are not only considered, which is the underlying responsibility of the Commission, but also that all viewpoints have an opportunity to interact with each other. Because it's that interaction that produces results, not the retreating to my corner and shouting my talking points, but saying, how can we engage in a dialogue? Because there are miracles that happen when you dialogue. So I want to thank our distinguished panelists for being here today. I want to thank John and Stephanie for leading the discussions. I recognize that Commissioner O'Reilly is here again. He has been here for all but one of these sessions, and that one that he missed, he sent a note from his mother. He actually sent us a note explaining that he had a previous engagement, that he had to be out in Kansas, and that he really wanted to be here. So, Mike, we appreciate what you've done. Commissioner Rosenworcel has been here for several of these as well, and I imagine we'll see her today too. So I've suggested that we can go and dialogue. I've been pleased with the tenor of the discussions that we've had thus far. By the time that we end today, we will have had over 24 hours of sustained, continuous debate and discussion on the important issues in the open internet. And I'm grateful to all who have participated, to especially those who are participating today, and I will get out of the way and turn it over to John and Stephanie. Thank you.
Thank you, Mr. Chairman. As the chairman said, the goal of the roundtables as a whole was to generate light, not heat. Today our task is to turn light into law. We'll do that by discussing the basis of legal theory that can provide the foundation for an open internet order. We'll be asking what's the best source of law to use. We'll be asking what's the best way to construct legal rules. We'll be discussing, no doubt, the history and the concepts of communications law. I think we should try to have two discussions at once, really. There are a lot of lawyers in the room, and we should try to be analytically precise for them. But as the millions of comments that have been received in this proceeding have demonstrated, questions of law have become questions very important to the public. And so we'll try to be clear for non-lawyers as well, clear about the way the law can provide the basis for policy that's very important. In fact, as past discussions have demonstrated during these panels, the history of law has been a frequent topic. The history of law, for example, telephone regulation in the mid-20th century. One of the panels featured a discussion that went as far back as railroad regulation. I won't go that far back to begin, but I do want to start with just an overview of the recent past. Since January, when the United States Court of Appeals for the District of Columbia Circuit decided the case entitled Verizon versus FCC. That's the case in which, as I think everybody knows, the court reviewed the 2010 Open Internet Order. And here are some of the important points I see when I read that opinion, and how other people see it will be a topic for conversation. First, the court ruled that the FCC has the substantive power under Section 706 of the Telecommunications Act to protect the so-called virtuous circle of innovation. The circle that exists when edge providers, that's the term that's used to include companies like Amazon or Google or Hulu, when edge providers use broadband to reach consumers, and the consumers, wanting to reach the edge providers, provide greater incentive for the building of broadband networks, for better broadband, for broadband reaching more places. At least that's the way consumer demand is supposed to work, because the court also upheld the Commission's judgment, and I quote, that broadband providers represent a threat to Internet openness and could act in ways that would ultimately inhibit the speed and extent of future broadband deployment. And it was that threat, of course, that motivated the 2010 rules. Nonetheless, the court went on to strike down the Commission's no blocking and unreasonable discrimination rules. This is a topic we'll get into, and it gets complicated. It gets caught up with definitions that have been used for a long time in this space. But basically, the Commission had ruled that the service of a broadband provider to a consumer was not that of a common carrier. A common carrier is the traditional designation given to telephone companies under Title II of the Communications Act. In other words, the Commission had found that the retail broadband was not a telecommunication service. It wasn't within the scope of that traditional regulatory structure. But the court found if Title II didn't apply, if there was no classification as common carriage, then the last mile networks couldn't be subjected to common carriage requirements. Now, here the court made an additional finding. The Commission had emphasized that there was one service being provided, a service to consumers. But the court found that there were two, not just one. A retail service to consumers, but also what it called a service to edge providers. In other words, the transmission of edge provider traffic from the edge providers to the consumers. And the court required that that traffic had been treated as common carriage. So the court's opinion leaves the Commission with a series of legal options. We'll be discussing them this morning. Here's just an initial classification of some of the options. The Commission could use Section 706 and create rules that don't equate to what the court called common carriage per se. Or it could change the treatment of retail broadband services so that they would be classified, or one should say reclassified, as telecommunication services, in which case Title II would apply. The Commission could answer the new question that the court asked, what is this other thing, what's the other service being provided to edge providers, and classify that, identify that for the first time. Or, and we'll talk about this, some people have suggested using one or more of these approaches in tandem, using them together at the same time. There's various flavors of these approaches. I haven't tried to capture them all, but what we do want to do is to talk about the different options that are available. What are their pros? What are their cons? What are the legal risks that are attendant to them? What are the legal advantages? And to do that, we'll start with opening questions. Just let me explain for a minute before we go there what the format is going to be today. Stephanie and I will ask questions, some of which are on our own, some from email, some from Twitter, other social media. The chairman and commissioners will have their own opportunity to ask questions. One thing I should note about questions from the audience, and that means both anybody in person who wishes to submit a question or those online. By submitting a question, you'll be making a filing in an official FCC proceeding, so all information you submit, including names and addresses and other personal information, will be publicly available online. The way we're going to work the beginning format is we're going to ask each panelist an opening question with 3 minutes to answer. There's a clock that will tick down. Then we'll walk our way through topics, and we'll try to keep the conversation going as we do. So let me start with the first of the 3-minute questions. Let me start with Tim Wu. You've had a busy year, Tim. You've been called the father of net neutrality. One of the things you did this year was to publish a paper in June entitled Sender-Side Transmission Rules for the Internet, in which you described 2 ways of applying Title II. Can you take us through how those would work?
Sure. So first of all, let me start by thanking you, John, and thanking the chairman, thanking the commissioners for holding this. It's a great honor to be here. Before I get exactly into how the sender side works, which I think is important, I want to start with a small background on Title II itself and my opinions. I have been looking at these questions for quite a long time, not since the railroad, but at least since the early 2000s, in fact, the late 1990s. And I just want to start with my proposition that I've never thought that this is a particularly hard legal question. With respect to those who disagree, if you're interested in the strongest and clearest authority of the Commission, I think it should use its main authority, which is the Title II authority. And I regard 706 and some of the other options of having legal risks. The closer you get to a strong net neutrality rule, the stronger the legal risks become of losing yet again in the D.C. Circuit and resetting this cycle over again, which I don't think anyone is interested in. That said, let me say, and I think people know there's different flavors of Title II. The one I described in the paper, co-authored with Tejas, who's around here somewhere in the back over here, is to suggest that there is an opportunity offered up by the D.C. Circuit, a very clear and I think legally unrisky opportunity to classify for the very first time the service by which the carriers, the ISPs, are offering to bring traffic to consumers. It has the advantage of using the FCC's main authority, which is Title II authority, which, as I said, the strongest, clearest, and has the most power for the for the future. I think will last a long time. It's been around the longest. On the other hand, has the advantage of not having. I don't think reclassification is legally risky, but I think that greenfield, first-time sender side would be even less legally risky. I think it would be a very straightforward legal decision to classify. Now, I don't know if I've done a good job explaining what is being classified. The ISPs are offering to the public, and particularly to those interested in sending internet traffic to consumers, they are offering them a service. This is what the D.C. Circuit made clear. They're saying, we will bring your traffic to consumers. The proposal would classify that service as a Title II service. Right now, it is in a state of legal limbo. This would be a greenfield classification for the first time. It's very naturally and straightforwardly under the definition of a telecommunications service, so I think would be of extremely low legal risk, straightforward path for the FCC to take for the future.
You filed comments in the open internet proceeding suggesting that the Commission should not use Title II, and if I understand it, that it would be legally risky to do so. Why do you think so, and what's the preferred course you would suggest?
So the preferred course that I would suggest, let's start with that, is 706, 706, 706, with a proviso there. It would be do almost anything that is not defining clear, bright-line rules. If the Commission defines clear, bright-line rules under either a 706 approach, a Title II approach, or some hybrid approach, or some other approach, we're going to end up in litigation. And these rules are going to be litigated for another 3 to 5 years at least. And as Tim just said, that's a place that no one wants to be. And most importantly, it doesn't do the consumer any good. We need this debate to be over. We need to have the Commission moving on to focusing on all the other myriad issues that, frankly, are far more important than network neutrality. And bright line rules, as a result, will not be in the public interest. They actually will be against the public interest. So the 3 points that I would generally make here are, first, following the Verizon decision, the Commission has clear legal authority under Section 706, under the Communications Act generally, to prescribe action that would be harmful to consumers, that would be harmful to the open internet. And this is a really fundamental point that I think the Commission has done, frankly, a very poor job of communicating. In fact, the public notice for this event, and this is something the Chairman has said several times in public, says that there are no legally enforceable rules for the Commission to prevent broadband providers from acting to limit internet openness. That's flat out wrong. The Communications Act provides this power. Section 706, the court has said, provides this authority. The Commission does not need to adopt rules in order to exercise that authority. Let's go back in time several decades into the mid-20th century on another front, administrative law. Since 1947, it has been black-letter administrative law that federal agencies can develop their implementation of their statutory authority through case-by-case adjudication instead of through, or in addition to, through rulemaking. The Commission does not need to issue rules, and if issuing rules is just going to lead to litigation, issuing those rules is not in the public interest. It is against the public interest. The second point, why will Title II end up in litigation? Section 706 with bright line rules, I think, also would end up in litigation. It's unclear what the scope of either Section 706 or Title II is. It's unclear how broad they are. It's unclear what the limits are. They're an invitation for parties to bring suit. In particular, a Title II-based approach, I think, the courts would be somewhat hostile to, especially if it's a Title II plus forbearance approach. The Supreme Court this past summer has raised substantial concerns about approaches that use substantial existing legal authority where an agency forbears or carves out the whole of that authority and builds something new inside of it. And the third point, given points 1 plus 2, the Commission doesn't need to issue rules. If it does issue rules, bright line rules, it's going to end up in litigation, so it shouldn't issue rules.
Thanks, guys. Just a matter of editorial privilege. I think the Chairman's statement about no rules being in effect was a relatively straightforward observation based on the fact that the conduct rules that were issued in the 2010 order had been rendered invalid by the D.C. Circuit opinion. We're going to have a discussion, certainly in the second panel, and maybe we'll find time to have it in this one as well, about the different ways that under statutory authority, the Commission can move under either rulemaking or adjudication in the way that you suggest. So let me turn to Nuala O'Connor, who's the President and CEO of the Center for Democracy and Technology. In comments that CDT has offered, you've both supported reclassification of the kind that Tim has also written about. You've, in addition, suggested what you call a hybrid approach, using both of the statutes we've heard about so far, Title II and 706. How would that work?
So, John, thank you very much, and Stephanie as well. And first of all, let me thank Chairman Wheeler and the commissioners for having the courage to take this issue on, once again, in the history of the FCC, to resolve this threshold question about open Internet. First and foremost, I have to say that we at the Center for Democracy and Technology support the discussion of all of the options on the table. We are grateful you are considering the familiar paths of exclusive reliance on Title II and Section 706, and we welcome the discussion about the various hybrid proposals, and they seem to flower more frequently by the day, while we do understand the existing legal structures and the challenges presented. But we are concerned about rules that preserve the nature of the Internet as we know it and the opportunity for the individual to engage in a full and rich digital life. That's what we are concerned about, their civic engagement, their economic growth, their personal expression. So as you said, our previous comments did note that we consider reclassifying broadband Internet access as a Title II telecommunications service. We think that provides a very stable basis of legal authority. We also recognize 706 as a possibility, but we caution that the commercially reasonable standard does not adequately protect the legitimate needs and expectations of the consumer. And so we are intrigued by the idea of a hybrid approach. And again, as I've said, there are many. The one that we discuss in our petition and is similar to the Mozilla May 5th petition would govern relationships between the ISPs and the edge providers separately from those governing those to the consumer. A proposal like that is consistent with the Verizon Court's recognition that ISPs provide distinct services to subscribers and to edge providers, and it recognizes that one of these services is a business-to-business model and one is business-to-consumer. The service that the ISPs provide to the edge of the network is segregable from the business-to-consumer relationship, and the Commission could classify the B2B relationship as a Title II service and then rely on forbearance authority to ensure that the rules are narrowly focused on prohibiting blocking and unreasonable discrimination against the edge providers while providing for reasonable network management. But for the business-to-consumer relationship, Section 706 could provide the source of authority for rules that protect consumers while providing for individualized negotiation and experimentation by the ISPs. As mentioned already, however, the NPRM's proposed commercially reasonable standard is insufficient to adequately protect Internet users. With the stronger standard, one that promotes Internet openness, the hybrid approach could provide adequate end-to-end open Internet protections. There are also the second hybrid proposal that has been floated recently would reclassify broadband Internet access services as a Title II telecommunications service, but would rely on Section 706 for the specific open Internet protections. And under this approach, Title II could serve solely as a backstop for the 706 rules. Versions of this approach appear in the AOL comments and in the recent letters from Congressman Waxman. And we encourage you to give them all your full consideration. Thank you.
Give AOL's particular consideration right now, because we're going to ask Pentalis, who's counsel for AOL, to tell us about how that proposal would work.
Thank you, John and Stephanie, and good morning, Chairman Wheeler, Commissioner O'Reilly, ladies and gentlemen. I think that terms such as Title II and Section 706 may generate greater enthusiasm in the minds of lawyers than in those perhaps of non-lawyers. I will try to talk about the broadband provision and common carrier rules. I'm sure I will lapse, in which case I will invite one of my neighbors to nudge me or hit me. Having represented the Open Internet Coalition in the Verizon case and prosecuted that case alongside the FCC, I do have a vested interest in the description of that decision as a victory for us. But I have tried to rise above this personal bias. And together with AOL, we have proposed, indeed, a hybrid approach. We have recognized that both of the possible bases for our Commission jurisdiction here each have its own weaknesses. And so the broadband provision has the weakness that the Verizon court said it cannot be used for a rule that necessarily confers common carrier status. For its part, the common carrier set of rules have their own weakness, which is that it can be argued, and I'm not saying this is a winning argument, but it is an argument, that those rules can be used to tell ISPs to charge everyone the same, and not to tell ISPs to charge everyone zero. And so we thought that we should try to make each of those sources of jurisdiction buttress and fortify the other. We believe the Commission should make tough, bright line rules under the broadband provision. I disagree with Gus on that. I think bright line rules have the advantage of bright lines. And so they should prohibit pay-to-play for large categories of ISPs, including those that have market power and those that have chosen to be in the business of charging end users, as opposed to the business of exclusively trying to make a living from the other side of the internet, from edge providers. At the same time, the FCC should conclude that the transport component of internet access service is separated and can be separated from the bells and whistles, from the information service bells and whistles, and therefore it is a telecommunications service. At the same time, the FCC should exercise its forbearance authority, should forbear from common carrier Title II regulation of that service, so long as it's not necessary. And it is not necessary while the tough rules under the broadband provision are in effect. If something bad were to happen to those rules, such as a reversal, then the forbearance would automatically expire and common carrier regulation would come back in force. We think this is a triple win for the consumer, the internet, and the economy. And as Chairman Wheeler said, this is not a monochromatic issue. And by the same token, it's not a blue or brown or black or white, either or mutually exclusive choice. We believe that instead of being mutually exclusive, the choices are complementary and mutually reinforcing.
Great, thank you. Let me turn to Mark Cooper, Director of Research at the Consumer Federation of America. Mark, you've written and thought a lot about the history of regulation in this space, Title II and 706 together. How does history inform, how should it inform our approach to the different alternatives that people on the panel are suggesting?
Well, as a non-lawyer, I have concluded that handicapping court cases is a fool's game. What you need to do is build a resilient and robust strategy, and we have argued for an all-of-the-above approach for strategic and substantive reasons. As you suggested, the threat of loss of network neutrality is existential, catastrophic, something that must be avoided. And yet you face severe ambiguity about your power and authority, and they're different. You misspoke, Jonathan. You have the authority under 706. You have the authority under 706, but you do not know whether the power you can execute is sufficient to achieve the goal. On the other hand, you know that if you reclassify, you will have plenty of power, but you can't be confident you will get the authority. Because the outcome is incommensurable, that's the term used in economics and ethics, and you face ambiguity, you should apply a precautionary principle that maximizes the possibility that you will have authority and power. To me, that means you should pursue both routes, but in a manner which separates them, so the failure of one does not cause the failure of the other. The biggest bet is not always the best bet. Sometimes you have to hedge your bets. From the point of view of substance, I think you want to pursue both, and that's where we get into the history. Internet data transmission was always subject to hybrid legal authority. It was Title I ancillary authority, which was made up by the court, subject to the doctrine. The 96 Act has narrowed that possibility. The court has kicked it back twice. We better accept that judgment. But they also said we have a different approach to flexibility, the combination of 706 and Section 10. And they even said maybe Title II. And so what you really need to do is rebuild that hybrid approach under the new law. Do the best job you can under 706, invoke some Title II authority, plus Section 10 forbearance, where you think you cannot get to behaviors that need to be outlawed or goals that 706 does not empower you to achieve. Now, these complex legal things may sound very complicated, but that's what we lived under the Communications Act, at least since 1947. Congress wrote the act this way precisely because they understood that the telecommunications changes much more rapidly than the law can. And the courts accepted the proposition that these pragmatic approaches to deal with change would be legal under the deference authority. Now we exist in an environment in which change is the order of the day. We need a regulatory system that can adapt to change. 706 gives you the flexibility you need as a broad proposition. Title II gives you the occasional bright line that you might need to avoid the catastrophic outcome.
Thank you. Let's finish with Tom. Tom's a former chief of the Wireline Competition Bureau here at the FCC. Tom, let me suggest two different topics you might want to address. One is there's been a lot of talk about the use of Title II. To the extent you have views about whether you think that's appropriate for the Commission, that would be important to hear. But there's also another legal issue. One of the questions that's pending before the Commission is whether to apply the same open Internet rules to mobile services as to fixed services. Mobile services are traditionally classified under yet another part of the Communication Act, Title III. So if you have thoughts about both of these things, do you think Title II should be used? Do you think there are any particular issues that would attend to the application of open Internet rules to mobile services? That would help fill out the conversation.
Thank you, Jonathan and Stephanie, for inviting me here today, and for Chairman Wheeler and Commissioner O'Reilly's commitment to open debate. I don't think there is much controversy surrounding the idea that these issues need to be vigorously debated, and I don't think there's much debate around the idea that the policymakers want to keep the Internet open. With regard to your specific question, it's hard for me not to feel a little nostalgic being here today and seeing some of those who taught me common carrier regulation. I was a student here to the common carrier teachers for about 8 years, and I learned from both the folks inside the building and practitioners from outside the building, like my friend Phil Favir over there. And I must admit that all of this debate about Title II strikes me that it would be a bonanza for attorneys, but not necessarily good for Internet innovators or Internet investment. Specifically with regard to the wireless carriers, Jonathan, that's, I think, the easiest case to make for a variety of reasons. I think the Selco decision made it plain that there's a double prohibition on imposing common carrier regulation on providers, wireless broadband Internet providers, who have been determined to be private mobile radio services. And I agree with the court in that description. I started here in 1999, and one of the things that we grappled with fundamentally was the idea of how to classify the service known as Internet access and how to classify Internet services in general. I think that the Commission got that decision or that determination very right by classifying them as information services and then ensuring platform parity so that all of the innovators that wanted to invest in these new platforms were able to do so with a minimal and light regulatory touch under Title I. Wireless providers face unique economic hurdles and challenges that some of the other providers don't face, such as the fact that the critical input to the wireless industry is spectrum, and that's something uniquely within the control, or not exclusively, but uniquely within the control of the FCC. So in reliance on that critical input, it would be odd to then, which constrains capacity, it would be odd then to require unlimited capacity by those providers to consumers or other providers seeking to reach the consumer. So I think that's a significant operational distinction on the wireless side in addition to the statutory distinction under 332.
Thank you. So we'll now go into questioning on a number of topics. Stephanie?
I want to stay with wireless or mobile broadband internet access for a minute. Tom, you just talked about the fact that the Commission may need to make a double finding if it were to apply Title II to mobile services. I'd like to ask for responses to that. I don't know if, Tim, you have thought about it?
Sure. I agree. I think the finding is right, that there would need to be a double finding, but I think our research suggests that is within the power of the Commission to do so. I think that increasingly, whatever the conditions might have been, let's say 5 years ago, the fact is mobile broadband has been a success and is increasingly used by people in much the way they use fixed wire. It's not as fast, but it is much, and they has become a situation of more or less parity, and so therefore it doesn't make sense, in my view, to have vastly different regimes for the two platforms, to have a network unneutral platform on mobile and have net neutrality in wireline. I've said before that I think Title II is the most straightforward, least legally risky way of handling this. I think the Commission can make the extra findings when it comes to the wireless platform, and I think that's the best path going forward. There's a real danger of distorting competition in the Internet application space if you have very different rules for wireline and wireless based on perceived technical differences. There are some technical differences which may yield more needs for reasonable network management. I concede that fact readily. But I also want to point out that most of wireless is also wireline. You know, most of what is happening on wires. It's obviously just the very last area. I don't have any reception here, unfortunately. But you know, in theory, if I was having reception, that would be the part that was wireless. But most of the connection is indeed wireline, and having these being under vastly different regulatory schemes, I think, creates dangerous situation that we aren't able to predict the results of. So I am against differential treatment of wireless and wireline.
If I may add, I agree with Tim on the statutory issue. I do think it's clear that Congress meant to give wide latitude to the FCC to define those terms, so that subject to the usual Administrative Procedure Act requirements, the FCC may do so. And as to the need for a second finding, I want to comment. I think it's part of a broader strand that perhaps we have heard about the fear of litigation, that we don't want to be embroiled in years of litigation. And this is, of course, a salutary objective. But as far as the chance of avoiding litigation following the Commission's decisions go, I think we can all agree that they are pretty slim. The FCC tried to use narrowly Section 706 and some other basis for its jurisdiction first, and that gave rise to vociferous litigation. The FCC tried again using Section 706, and that again gave rise to robust litigation. And so I don't think that we should be using the criterion of avoiding Title II or avoiding double findings in the interest of perhaps eliciting some form of a consensus. I think rather the criterion should be how to best fortify the Commission's decision to maximize its chances on appeal.
Gus, just quickly.
There's an important aspect to the wireless discussion that I think we need to make sure we keep in mind, which is the wireless market is far more competitive, far more robustly competitive than the wireline market. There are 4 nationwide carriers plus regional carriers in most markets. So any rule that the Commission adopts should be attenuated to have some safety valve for competition. And in particular, in competitive markets, we expect to see we expect to see experimentation, development of new services, some of which will fail, some of which will succeed, and they'll be tested by the market. Any wireless rules that the Commission adopts need to be careful to preserve that form of competition, allow for that type of experimentation, because that's what's good for consumers, and that's what drives consumer welfare. And I'll just note, my phone has 4 bars. I won't say which carrier it is,
well,
though.
I just want to note that there is Wi-Fi service provided by the FCC to people here who choose to use it. So let's start to go back through some of the options, go into a little more detail, starting with reclassification of the retail service. Just to set the stage on this, the Commission decided in a series of orders that the service being provided by Internet access providers to consumers was a, quote, information service, which under the Telecommunications Act of 1996 is different than a, quote, telecommunications service. Title II attaches to telecommunication services. Nuala, let me begin with you. In CDT's comments, you suggest that the way Internet access service is being used today more closely resembles or is a telecommunications service rather than an information service. Can you tell us how you approach the reclassification from that vantage point?
Our most significant concern, and as we've said before, we do feel it is the safest play. I like Mark's analysis about big bets and small bets, but it's the safest play to reclassify as a Title II service because of the concerns about no blocking and non-discrimination that the Verizon court raised. So that, to me, is the fundamental question. How do we achieve the baseline non-discrimination in a permanent, lasting piece for the consumer? And so because of the ubiquity of the Internet services offered, because of the essential nature of the services offered in the daily life of the citizen, we are concerned that any option less than a pure Title II play would not have the permanent lasting effect of a baseline non-discrimination rule.
And so let's talk about, anybody want to talk about what it would take, what kind of factual findings it would take to support a reclassification? Mark?
Well, look, the original decision was, you can argue, was fundamentally flawed. It was incomplete. The agency recognized that there were many important issues like universal service which hadn't been dealt with when they reclassified. They even said, hey, let's have a proceeding. Some people would have said you ought to finish the universal service proceeding before you reclassify, and the consumer protection proceeding and the public safety proceeding. So one could have argued they should have done that first before they but they went ahead and reclassified anyway, and they never finished the other proceedings. So you have a basis there for arguing that the Commission acted prematurely and it's time to revisit. We've had over 10 years under that decision and we failed. Let's be clear. We've had 10 years of the cable modem order and we have failed to achieve reasonable and timely deployment. A decade in cyberspace is an eternity. It is time to revisit a flawed decision. You can argue that a lot of... Remember that decision? Broadband over power line was going to save us. How many people in this room have broadband over power line? How many people in America have broadband over power line? There are all kinds of economic, technological, historical, legal, policy flaws in that decision. So we can argue that it was poorly made, and then we can also argue that the world looks very different today, and that's exactly why the Act is flexible. It says now, 10 years later, you know what? The terrain has changed, and we want to change our mind. So I can make a really good case for going back to Title II. I have another question. I'm not sure we want to live under Title II for policy reasons. And so that's why I advocate the hybrid. And let me say this business about litigation. It turns out in America the prime directive is thou shalt litigate. And nobody should make a decision on the basis of whether or not there will be litigation. There will be litigation. And so what you really need to do is pick your policy. You could make a good case why Title II was the right answer in 2002 and is even more the right answer today. But then you really want to ask yourself, is that where I want to live for this dynamic telecommunications environment?
So, Gus, let me phrase it this way. As I understand the argument that people make, it's that the Commission found that an Internet access service was an information service because the transmission came with other stuff, like email addresses and websites. And the argument to the contrary today is that, by and large, people are buying just the pure transmission. They're not using email addresses that are necessarily attached to the ISP or websites as home pages attached to the ISPs. You've said, though, that adoption of Title II as a legal basis would almost certainly result in additional years of industry and consumer uncertainty as the Commission rules are challenged in court. Assuming, as Mark says, we should assume that there would be litigation, what do you think would be the outcome of that litigation? Do you think the Commission would be upheld?
Wow, a lot of stuff in there. First, I really want to get broadband over power line, just so that I can say yes when Mark asks, does anyone here have broadband over power line?
Physics doesn't work.
Right, I know, but so first, on the reclassification question, or depending on your perspective, reclassification, classification, as a legal matter, purely legally, I think the Commission does have broad authority to classify Internet as Title II. Under Fox 1, a 2007 case, the Commission can reclassify without heightened burdens, and the Commission will get substantial deference. It's actually somewhat ironic. There's a bit of a quirk here. I think that I'll disagree with Mark, however, and say that the argument for information service classification is stronger today than it was a decade plus ago. A decade plus ago, the key thing the court looked to was the inclusion of DNS service. Today, arguably, we also have a lot of security services in the background, a lot more management in the networks, and in fact, the way the modern networks operate, arguably, most telecommunication services are actually being provisioned as information services over IP backbones. So arguably, there are no more telecommunication services. Everything is an information service today. In terms of the litigation outcomes question, my answer is simply, I don't know. These are really complicated questions. It's unclear what the contours of either Title II or 706 are. I have a great deal of uncertainty about the prospects for the Commission. If the Commission adopts bright line rules, I have a lot of trouble seeing the D.C. Circuit in particular not rejecting them as arbitrary and capricious. If the Commission does take a hybrid approach, a Title II plus forbearance to establish some authority, including 706, I have a lot of trouble seeing, under recent Supreme Court precedents, that being upheld. One last point, responding to things that both my right side and left side, who I think both are to the left of me, even though I'm in the center, have said. The question of authority and litigation. Litigation probably is inevitable, but the Commission has a lot of ability to control how and when that litigation occurs. The problem with the bright line rule approach, the problem with the 706 versus Title II debate, is that it is assuming the existence of a problem, and it's unclear what that problem is. The nature of the problem speaks to the nature of the legal authority that should be used. So it is very likely that litigation is inevitable. It would make much more sense, I think, for the Commission to take a step back and say, we clearly have Section 706 authority. We can reclassify if we want to. Everyone knows that we're watching you, industry. If you do something that's harmful to consumers, I, Chairman Wheeler, will bang my gavel down upon you like the hammer of Thor. That I think, is the best approach.
Yeah, I just want to emphasize, Gus, that the seating here is alphabetical, not ideological. More on this topic. Let's go Tom and Tim, and then we'll move on.
I disagree with the idea that the commissions can simply reclassify broadband internet access platforms as telecommunications services. So I think that would face an extraordinarily high hurdle to get over not only the legal obstacles but the economic obstacles. Even in 6th century Roman law or 18th century English law, you weren't compelled to offer your services on a common carrier basis, but if you offered those services indiscriminately to the public, then you couldn't, in that case, discriminate. So that's a significant point here, because the Brand X decision sustain the Commission's determination that what the wireline broadband internet access provider is providing to the end user customer is an information service, not a telecommunications service, and that's significant. I don't think you'll be able to get by that obstacle. 706, I mean, I was quite stunned at the breadth of the Verizon court decision in terms of how much authority it gives the Commission under 706. Provided that it's operating under its Title I authority, which is expansive, it allows the Commission to reach all interstate and international communications by wire or radio, and provided that the Commission is adopting a rule designed to promote broadband, as long as it doesn't run afoul of another prohibition in the Act, it has authority. So the Commission has wide latitude under 706. I think it's somewhat surprising to hear people suggest that the Commission cannot adopt Internet rules under 706. I think that is wrong as a legal matter. And I just want to, again, emphasize the wireless broadband Internet access providers constructed their network for the purpose of offering an information service, which is the safe harbor the Commission created for purpose of them building those networks. I think it would be highly doubtful that the Commission could compel them to unbundle a transmission component. And on Mark's point about how the Commission moved in an incremental fashion, what I would say is a couple things. Number one, Section 254, as it relates to universal service, allows the Commission to assess a telecommunications component. So in that way, it's in Title II, but it's distinct because it allows the Commission to regulate a telecommunications component and assess a telecommunications component, which is in part the way the Commission was able to bring interconnected VoIP providers within the ambit of the Universal Service Program. If you want an example for how difficult it is for the Commission to engage in classification determinations in the first instance, what I would point to you is the fact that 18 years after the 1996 Telecommunications Act, the Commission has not classified interconnected VoIP services. That's how difficult classification and reclassification decisions are.
Tim, I know we're going to go to you next to talk about this issue further, but I also hope you could bring in the concept of forbearance. I think almost all of the panelists who've talked about Title II on either side have talked about forbearance. So as you discuss your approach to reclassification, can you also talk about how we should apply our forbearance authority? And just
Sure.
For a moment, what we mean by forbearance. In 1996, Congress enacted Section 10 of our statute, and that gives the Commission the authority to forbear from other provisions of the statute, and that's where the Commission has found that the provision is no longer necessary to protect consumers, protect the public interest, or ensure that rates are just and reasonable.
Sure. Thank you. And since you've asked about forbearance, I see you've given me 21 minutes to talk about it. But I won't use it.
Wait a minute.
All right, so I want to comment on a few. I assume that's a mistake. But
Yeah, I'm not sure.
Thanks. I agree. I want to comment on a few things that have been said, first of all. I agree with the people who have suggested there will be blood or there will be litigation. I think every time this Commission has hoped that there won't be litigation, that's failed. One of the things that, speaking of history, when you go back to the original design of this, of the Federal Radio Commission, it was Federal Radio and then Federal Communications. It was originally designed, and for most of its history, this agency has been dealing with a relatively small number of players. And that was easier in some ways. But I think now you're dealing not even a handful, not even dozens, but actually millions of people and millions of innovators around the world who are watching, but in this country who you have jurisdiction over. And that requires a different kind of approach. It requires an assumption that someone out there will litigate, for example. But also to go to this issue about bright line rules versus case by case, it also suggests you can't solve everything just by a few meetings. The case for bright line rules in this area, I think, are that the people who are not watching this webcast, people who are not in this room, people who aren't in D.C., only know one thing. Are there net neutrality rules or not? They see this as a very binary kind of thing. When I think about innovators who are working maybe, and all they're going to read is a headline, there aren't net neutrality rules or there are. And that's it. And so we can, in this room, have this idea that people are going to very carefully parse over the NPRM and the final rule. But in fact, I think a lot of the audience, the relevant audience, innovators, only hear that. And so that's, I think, the case for bright line rules. And the other case is that the general understanding for the last 10 years has been, one way or another, there are net neutrality rules. They are on in some way. And that signal has triggered an enormous, amazing period of innovation that everyone agrees has been the envy of the world. It has removed the question as to whether America is the technological leader of the world, which was a question in the 80s and 90s. Now it's obvious that in the Internet sector, the United States is the world leader. And I think some of it, not all the credit, but a lot of the credit does go to the fact that we have an innovative Internet, and below that people believe there's a net neutrality rule. So I think that's important. Going to this question of where the greatest legal risk lies. Now, we are all obviously speculating. My view of it is that the 706, to my mind, incurs substantial legal risk if you are doing a real net neutrality rule. The problem is that the closer you get, the Commission is in this with 706 is in a difficult position, the same position other commissions have been in, which have led them to be struck down over and over, which is they want to have really strong net neutrality rules, which as a policy matter and as a public pressure, I mean, you have millions of people insisting you do this, and you want to send the right message. But then the 706 authority is only so strong. And so you end up in this thing where you make the rule stronger and stronger until the point, listening to feedback around here, you get in the position where you get struck down. So I think 706 ends up being risky unless you're willing to accept a slow lane, fast lane. But I don't think you're willing to do that. I've heard the chairman himself say that he does not want to create an Internet a slow lane, and I take him at his word. So then you have Title II options. In my view, reclassification would be successful legally. I think there's a lot of agreement. I'll be more polite. Mark Cooper said it was wrong from the outset. I would say it is obsolete. If you read the cable modem order now, you'll say, I don't really think people sign up for broadband because they want a web page and an email address. Like, that's just not what people think. They come to their house, you know, they're in a new place or a new business, and they're like, electricity, water, broadband. You know, all right, turn it on. Where is it? And no one's thinking about, do I get, a Comcast homepage with a deal? It's just not the way people are thinking. They think of it as an essential service, as a utility. So I think that would succeed. I also want to reiterate that I think the legally safest option is sender-side Title II. It is a new classification. There's no need to go through the reclassification. It is a natural-born telecommunications service. There's no question whatsoever that what is being asked for is only the transmission of information without it being altered. And so it fits very clearly within definition. I don't think the Commission can lose with sender-side Title II. You asked me to talk about forbearance. I'm sorry, I've been going on a little too long. Forbearance lightens all of our days, makes some of the most serious consequences people talk about not real. I think the Commission has had a terrific record of using forbearance in all kinds of places. It's a great tool. It's one of the Parts 96 Act that I think was successful. And, it gets a lot. People who love the FCC will be like, some of our rules are a little too tough. That's when we use forbearance. My vision of forbearance would have the Commission forbear from most of the provisions, with some exceptions, 201, 202, 208, 222. Technically, those are the sections in particular, I think, that should be maintained at a minimum. The thing about forbearance, the Commission has done it many times. It's not challenging. I think the findings are obvious, and I think it's the right road forward. And just the last thing I'll say, where forbearance and light touch Title II have been very successful is in what we keep talking about, the mobile space. And if it works for mobile, it ought to work for the broadband internet. Light touch Title II, I think, is the right way to go.
Thanks, Pentelis. I know you have an approach that has a different take on forbearance, and then we'll go to Gus.
Yes, I know there was a lot covered, and if I may, let me start with the weaknesses of 706 and Title II, respectively. As far as 706 is concerned, let's look at the weakness, what the court said. The court said that it's okay if rules under, and I said 706, the broadband provision, are consistent with the common carrier regime. What it minded was if they necessarily confer common carrier status. Now, let's stand back and look at the hybrid approach. The rule that the Verizon court was applying was a rule that says a telecommunications carrier shall be treated as a common carrier only to the extent that it provides a telecommunications service. With the hybrid approach, the FCC has decided that indeed that telecommunications carrier provides a telecommunications service. So that section goes away. And I think this takes care of the major weakness that Tim identified in connection with the broadband provision. Now, as far as Title II is concerned, I want to register a mild disagreement with Tom's view. Reclassification is a big word. I think what you asked about, John, is whether the FCC can decide that the transport component of Internet access, which everybody is admitting exists, is separable from the bells and whistles. And I would like to move briefly from ancient Roman common carrier law to the Brand X case, where Justice Breyer said, yes, it may be reasonable, but it barely makes sense. And Justice Scalia said it does not make sense, using the pizza delivery and pizza analogy. And so I think that if anything is certain within the topics that we're discussing, the ability of the FCC to rule that this transport element is separable from the information service bells and whistles provides as high certainty as can be achieved. And I think the weakness, rather, of Title II does not have to do with this decision, but it has to do with whether you can use Title II to tell people, here's a service for which you have to charge everybody zero. And I think that forbearance and reliance instead on the now broad powers given by the broadband provision takes account of this problem.
So, Gus, do you have concerns either about the approach to forbearance that Tim sketched out or the one that Pentelis said, and then we'll go to Mark?
Yes. So the big thing that I want to say is don't take my word for it. I have been really quite shocked over the last 6, 7, 8 months as these discussions have been happening with how hard it has been to find law faculty, legal scholars, who think forbearance would be easy. Almost to a person, as I've been at conferences, been at panels, organized conferences, and have tried to find strong Title II supporters, I've found a very consistent viewpoint that Title II plus forbearance, this forbearance idea is a lot harder than advocates and the scholars who are advocating for it suggest. So that is, I think, a really important data point to consider. On the wholesale Title II idea, the idea of applying Title II on the edge provider side, it is a new idea. I don't think that insulates it from legal challenge. If anything, I think it opens it up to a wider range of legal challenge. The fact that the D.C. Circuit threw out this idea in dicta when they weren't really considering this idea, it hadn't been briefed or argued, the commission had never considered it, I think that's basically worthless. It will be challenged. There's no question that if the commission goes down that approach, there will be legal challenges to it. And the last point, the reason that we have the FCC, the reason that we have an expert technical independent agency is precisely because these are hard issues that ordinary consumers, ordinary legislators don't understand. The fact that lots of people are worried about net neutrality, that's not a reason to have a rule. That's a reason for the Commission to have public leadership and to get out there and say, look, consumers, we are here to protect you. The court said we're here to protect you. This John Oliver guy, he's not a lawyer, he's not an economist, he's not a technologist, he doesn't know what he's talking about. In fact, he works for a company, he's being paid to represent a company that has a vested interest in the outcome here. So does Netflix. Listen to what they're saying with some skepticism. We're the experts. We are here to enforce the law, to do what the statute tells us to do, to protect the public interest, not to address concerns that are being fomented by interested parties.
Well, let me just turn. I'm going to come to you.
I would go.
She did?
Yes.
Is it enforceable?
She
Is that an
acknowledged it.
enforceable problem? Have you relied?
He didn't interrupt me, so he relied.
Briefly, Mark.
Briefly.
Well, the question of latitude, it's remarkable. Telecommunications is defined in the statute regardless of the technology used. No technological questions. Chevron was deference. No law or policy. It was pure deference. The field is open. Second of all, the really interesting question of bright lines. Let's be clear. Carter phone, computer inquiries, spectrum are bright lines done at the agency's motion, not law. Worked magnificently, so bright lines can work. Sender side, really interesting. The first sentence of the 96 Act tells me that anyone who brings, in the private sector, facilities to increase broadband and competition should get deference. So I call that ought to be correct. So software is a little different. Hardware is very clear. Finally, with the handicapping. Having said it's a fool's game to handicap courts. You got to handicap the courts, right? If I see one horse limping, the other horse prancing, maybe I should bet on the one that's prancing. So 706 has just been upheld by 2 courts, and one of which even said you can mix 254 in if you want. And one of which said, and oh, by the way, we've upheld an approach to implementing 706 in the data roaming order. All of that is fairly recent. So Tim says he looks at Title II and says the probabilities are there. I look at those cases and say, if I have to do a precautionary principle, this horse is prancing. And so maybe you do that, maybe you need a lot more, but you got to get that core protection down.
So this is where I wanted to go, Mark, and so you may want to address this, Nuala, anyone may want to address this. Let's just take a minute to introduce 706 as a concept alongside Title II, and then we'll use the remainder of our time talking about mixed approaches, hybrid approaches, and the kind of harm the legal rules should deter. So just to remind people, 706, included in the Telecommunications Act of 1996, instructs the Commission to encourage the deployment of advanced telecommunications capability, in other words, broadband, to all Americans by utilizing a number of different tools, including measures that promote competition in the local telecommunications market or other regulating methods that remove barriers to infrastructure investment. In another section of 706, the statute calls upon the Commission to make an annual determination of whether deployment has been proceeding in a reasonable and timely manner, and if not, then the Commission is to take immediate action to accelerate deployment. So, taking 706, here's what some people are saying in light of the Verizon opinion. They're saying, in the Verizon opinion, the court was not faced with specific findings of harm about a particular kind of practice, and that it would be, therefore, consistent with 706 if the Commission found on a record of fact that there were kinds of practices like paid prioritization that were actually harming people, if it identified those practices, and if it either banned them or presumed them to be illegal. Nuala, do you want to take a shot at whether you think this is an approach that a court would uphold or should be used?
So thank you so much, John. I don't even know where to begin. There's so much to respond to in what's just happened. I can argue for 706 almost as vociferously as I can argue for Title II, with the one main caveat that the commercially reasonable standard seems an inappropriate fit for a proceeding about the open internet. Again, our goal is to protect the end user. Yes, we are concerned about innovation, we are concerned about the incumbents, and we are concerned about new entrants to the market. But at the end of the day, as was said in the Verizon court, all of us can be edge providers. Any creator of content, any individual can be an edge provider, is a creator of content, is a speaker on the internet. 706, again, presents an opportunity for a light touch regulatory approach and has many of the fine qualities that we could possibly see in a Title II ruling with a strong open internet standard, one that determines that certain practices are inconsistent with internet openness, with equal access, with a level playing field for the consumer. It reminds me of the comparison I make between scuba diving and snorkeling. For those of you who scuba dive and those of you who snorkel, snorkeling gets me 90% of the fun and 10% of the work. So honestly, there's something to be said about a light touch regulatory approach. That being said, we see the language from the Verizon court that we have come precipitously near a common carriage, and I think that is a very real concern. That being said, we have spent a lot of time today on the litigation threat. This is not a way to make a rule. The way to make a rule is to think about what are the principles we are trying to enact and speak with courage. And I think Chairman Wheeler is doing that in this proceeding. So I would remind you of the principles that we are concerned about, and they are no blocking, no discrimination. Reasonable network management is okay and could encompass an equal playing field for mobile and for wireless and wireline. And we want clarity and transparency for the individual. We want to know what the principles, what the practices are behind the scenes. We are talking about, with all due respect to our history, as was said at one of the Anglo-Irish Peace Accords, we bow to our history, but we will not be bound by it. We are talking about the internet, people, not Roman law. We are talking about what's going to happen 20 years from now. The internet is no longer something you sit down at your desk to do. It is not even something you get on your phone. It is something that is going to be embedded in the walls of your house, in the dashboard of your car, in your daily life. These are the rules we need. We need rules that encompass technology in your daily life, not the internet of 20 years ago. This is not your grandfather's internet anymore. Thank you.
On 706, anybody else want to take on Tom Mark on 706? Then we'll go on, if that's okay. I was going to go back to Sunder's side after that.
There's so much to respond to. First, for purposes of the idea of dividing the communication up, that is antithetical to what I was taught here at the Commission, and that is the first thing that you have to do is jurisdictionalize the traffic. In order to do so, you have to look at the end-to-end communication. So I think in that way, this idea of a two-sided market is flawed based upon how the Commission has treated the jurisdictionalization of traffic. Secondly, with regard to forbearance, I can tell not too many people in the room have worked on an actual forbearance order. By way of background, I'm trying to think of an instance where the Commission didn't take 15 months to resolve a forbearance petition. Why is that significant? Because the statute says that the Commission will resolve a forbearance petition in a year's time unless it chooses to take an additional 90 days. And in every instance, it takes 15 months. In part, that's because the criteria under the forbearance portion of the statute requires the Commission to make some very difficult findings about whether or not a regulation is necessary to protect consumers. So on the one hand, you would be proposing to make findings that would allow you to impose Title II, which certainly would include a conclusion that the regulation is necessary for the protection of consumers, and then on the other hand, you would have to apply the forbearance standard, which says that the regulation is not necessary for the protection of consumers. So you would be at cross purposes in that way. With regard to 706 as a source of authority, it allows you to both prevent blocking, prevent discrimination, as long as the Commission crafts its rules in a way where it does not run afoul of some other provision of the Act, including the common carrier prohibition. So I think the Commission has ample authority under 706, and I think that in this instance, it doesn't even need to take an incremental approach. It can ban both blocking and discrimination.
Mark, did you want to say something? Then I've got a question for Tim.
So here's a couple of ideas about how you develop 706 that it can get the job done. First, I think you got to shift the burden of proof. The traffic flows while the dispute is ongoing. That has been the principle that we had for the successful first 40 years or 50 years of the Internet. Second of all, I would ensure the permanence and the durability of 706 by defining the ultimate goal as 90% penetration of true broadband, which is what we achieved in the telephone age. And third, you can specify factors. the famous factors that will be considered. And here's 6 candidates. You might have more, you might have less. Not degrade the quality of service to the public, not be exclusive, not be anti-competitive, not be discriminatory, demonstrate a need for the differentiation, and demonstrate that there's not a less intrusive alternative. Those would be factors that would be considered to adjudicate whether a negotiation failed or whether the outcome is not commercially reasonable. So you can design 706 like the computer inquiries to get a lot of behavior going forward, and then that will discipline the negotiations. We need some discipline in these negotiations. If you look at the Netflix filing, there's a difference of opinion between Netflix and Comcast of 20 times. Netflix says it costs X, and Comcast says it costs 20 times X. Those kinds of differences are not easy to negotiate out in the marketplace. And so there are clearly some disputes that will end up here. If you give them a good set of rules, they might come in with a 5 times difference, which is easier to resolve.
A quick 15-second point.
Sure, 15 seconds.
I think that it's worth noting, if the Commission were to adopt a commercial reasonable standard with a strong presumption against paid prioritization, I do not think that would be a trigger for litigation. So I think that that would be an acceptable provision to almost all parties in the ecosystem.
So we've talked about Title II reclassification. We've talked about 706. I want to go to this edge service, to the sender side. So Tim, back to the approach you've talked about. It incorporates some of what Nuala's talked about. The Mozilla Foundation has made its own proposal that people think resembles your sender side proposal in the sense that it focuses on what is the last mile network providing to the edge. Mm-hmm. One question that's arisen, some people have objected to this because they've looked at the following definition in the Act and they've raised a question. Telecommunications service is defined as the offering of telecommunications for a fee directly to the public. And some people have argued that those requirements, particularly there's no requirement of a fee if the service is provided to all edge providers. How would you deal with that in using your sender side approach?
Sure. Let me address that question. But of course, I want to have a word about 706 first, just for 1 second, which is I think the temptation in using 706 is an understandable one, which is to say, let's make this problem go away. Net neutrality, there's this sort of perpetual desire with net neutrality to hope you could sort of come up with exactly the right compromise that makes it go away. But I want to suggest, and maybe the references to Roman, medieval, FRC, and other laws suggest that these problems actually don't go away, that they are long-term problems. I think Nuala is right. These issues, as wearables become more popular, as our refrigerators start talking to our laundry machines, as robots run our schools or whatever happens, none of these issues are going to go away. They're going to be with us forever. And I hate to tell everyone this because everyone's always hoping, oh man, I'm sick of net neutrality, I'm sick of this. Maybe it'll have a different name. Maybe someone will come up with a better name. But these issues do not go away. And the Commission needs to be thinking long-term about what kind of foundation it is setting itself up. The problem with 706, to my mind, is that the Commission will handicap itself in a long-term basis if it is not able to use or even touch the word common carriage rules. Some of what they want to do will resemble common carriage rules inevitably, now and then. Not everything, but for the going forward, decades going forward, to never being able to ever call something a utility when something becomes so essential as water or electricity is really a dangerous handicap for this agency over the many decades. So I urge the agency to think long-term, realize this problem will be with us forever, and to settle on the most stable basis of authority as opposed to a flimsy thing like 706, where when you read the text, it doesn't even, if a law student reads that text, they're like, what is this? It doesn't read like a grant of authority. 706, Title II, is the basis of this agency since 1936. Its main guns on the battleship, as we put it, and some other things. On edge service, there's this question of for a fee. The good thing about being an agency is that you get to define what the terms mean that you administer. And I think for a fee can easily be defined. I think that the agency can define the phrase for a fee to include two different possible bases. One is the idea that, in fact, when consumers are paying their money to their to their ISP, that fee is in part paying for the entire scheme, which involves edge providers sending through ISPs. So the fee is paid by the consumer. Ultimately, consumers always pay for everything anyways, no matter what we say otherwise. The other theory of economics, the other theory is you say, the word fee refers to the exchange of things for value. When two ISPs, two internet companies are exchanging traffic, they are perhaps not exchanging things in dollars, but they are definitely exchanging value, and therefore that is satisfactory of the definition of fee as we understand it. I think the Commission would get Chevron deference on its definition of these questions. They are technical. The reason that the exchange is actually not for a fee is because the transaction costs of trying to do the fee would be too much, and so it's not actually free. No one thinks of this. You can't go up and say, "Hey, I want this for free." In fact, there is clearly a fee would be charged if it could be charged if the transaction fees, the transaction costs of charging it were reasonable. Just nobody wants to try and bother with it. So that's how I think you satisfy that. Thank you very much.
So this is one of the reasons I take it you think the center-side approaches would be upheld in court.
Yes, that's right.
So let me ask a question. Gus, you may want to talk about this. Somebody else may. One of the ways that this works is, of course, to have an ISP that's supplying a service to retail customers that could be treated under one statutory provision, while the service to edge providers is treated under Title II, say under Tim's approach. Does that strike you as legally sound?
It strikes me as legally plausible. I personally do not think it is legally sound. It's conceivable to me that a court could agree with that. It's also conceivable to me, and as when I'm putting on my administrative law scholar hat, Tim's exactly right. It's a Chevron question. It's a question about, this isn't a question that the courts will decide. The courts will decide whether or not the Commission has been reasonable in its interpretation, and the courts have very broad authority, give agencies very broad authority here, but not unlimited authority. And the court in the last couple of years has decided a couple of really important and frankly confusing cases. This is an evolving area of law. When it comes to Chevron deference for scope of agency authority. One of the key cases is City of Arlington. This was a case involving the FCC where the court gave the FCC deference in interpreting a statute that related to its jurisdiction. Over the summer, the court also decided the Utility Air Regulatory Group of the EPA, where the court curtailed Chevron deference to the EPA when the EPA was finding some newfound authority in a statute that had never offered this authority before. So this seems to be a case that's somewhere between those two. I also just want to note, we have seamlessly shifted into a discussion about the Commission regulating internet-connected devices, dishwashers, refrigerators, robots teaching our children, our robotic pets when their feeding robot calls them for food. That's a very different discussion that we're starting to have, and I'm actually not going to be critical of it. I think it's problematic, but it's a reflection of the point that Tim made, that the Title II framework is a framework from the 1930s. It's the past. We're moving into the future, and the Commission isn't in a position right now where it can address the future. Much of the reason we're having this trouble is we're trying to fit square pegs into round holes. We're trying to apply these old statutes to modern settings. I think the Commission needs to get together with another commission, the Federal Trade Commission, and do a serious report and approach Congress and say, look, the future is different. Neither of us has clear statutory authority in these areas. We need to do something, because what's working is a recipe for ongoing disaster.
Well, I think the pegs are round, as are the holes. I think that I agree with Tom. Section 706 is capable of giving more powers than the Verizon case has sometimes been interpreted to give. Because the Verizon court said you can have a regime that is consistent with common carrier duties. And Justice Thomas in Brand X put it even more bluntly. It said he said the definition of telecommunication service has nothing to say for the Commission's ability to impose tough obligations on facilities-based information service providers. But to eliminate even the residual uncertainty, even about how far you can go with Section 706, the decision that the transport component of Internet access is a telecommunication service removes that residual uncertainty.
Let me interrupt you because I want to ask you another question, and then we'll go to Mark. Because you've taken us where the next question was going to head. We've talked about hybrid approaches or using 706 and Title II in tandem. Recently, Congressman Waxman submitted a letter to the Commission in which he proposed a particular way of doing that, which would be to reclassify the transmission services as telecommunications, to forbear from the application of Title II, but to enact some bright line rules. Do you think that's a compatible legal approach with what you're describing?
Absolutely. I think our proposal, AOL's proposal, is almost identical, indeed identical in its essentials, to the Representative Waxman proposal as reflected in the October 3rd letter. And with respect in particular to the forbearance portion of Mr. Waxman's proposal and Tom's point of forbearance, I want to point this out. The question under the statutory forbearance rule is whether essentially, it's a three-part test, but essentially whether regulation is necessary to protect consumers. Now, when on the side of the common carrier rules and Title II, the FCC has made tough rules under the broadband provision that say no pay to play, to me it seems, Tom, that the determination that those tough rules make it unnecessary to protect consumers by using common carrier rules, a very straightforward exercise. Not one that would last 15 minutes, but one that would last a very finite amount of time.
Mark, did you want to address this?
Well, with respect to that, Congressman Waxman and I want to get to exactly the same place. Not surprising, since we both vigorously supported the Open Internet Order in the first place. The difference comes in the question of he's focused on power, and he risks authority by overarching the reclassification. I want to separate them. So I want to make sure I have authority, and I risk power. I understand that. So we want to get to the same place. I think the idea of pointing to 706 as a blanket justification for forbearance is very interesting. The real question is, though, what happens when you no longer have 706 authority? But as an easy blanket way to do forbearance, it is really interesting. With respect to sender side, let's be clear. Title II gave us special access, third-party pays, and private line, all of which would have sounded like, boy, that doesn't fit under common carriage. So why not sender side, especially when we have the Act, which has put in the first sentence a desire to have these behaviors. So I think the people who say that you can't get it in the law either don't understand what Title II did, and Mr. Waxman understands that Title II did not ban lots of stuff. And two, they don't appreciate the intent of the 96 Act. So I think sender side is easy peasy. I think Mr. Waxman has come up with a forbearance approach that makes Title II easy peasy. I just want to segregate them, so if I lose Title II, I still have 706.
Easy peasy, for those non-lawyers in the room, is actually the particular phrase the Commission uses to invoke so-called Chevron deference.
That's there you
people
go.
to know. Gus, if you wanted to say something, briefly, because there's one more topic I'd like to get to before we finish.
Sure. Just make one comment, because I think there's a misunderstanding. The Commission's Title II authority is not unfettered. In other words, the Commission cannot compel someone to become a common carrier. The Commission can make a pronouncement if someone is in the business of offering transmission indiscriminately to end users, and they are seeking a fee for that. Then the Commission can pronounce them to be a telecommunications carrier. but the authority is not unfettered. The Nehruck line of cases established that fairly clearly. So I just want to make sure, because everybody assumes that because the commission has this Title II authority, that it can compel someone to become a common carrier, and that's just not the case.
Right. There are statutory requirements. Gus?
Tom's point is incredibly important. I just want to highlight that describing Senator Waxman's proposal as very interesting. Very interesting is lawyer for probably illegal. It's very clever, probably too clever by half. I don't think it's authorized under statute, and I think the courts would be very likely to reject it.
So I want to take the last about 10 minutes to talk about something we haven't talked about yet, which is what kind of harm can legal rules under the open internet address, right? What are the kinds of harm that open internet rules can prevent, and if they were to occur, punish? Much of the conversation tends to talk about economics, paid prioritization, impact, very important questions of impact on startups. But let's start this part of the conversation, and Nuala, you may want to do this, by talking about free expression, right? The Commission in its NPRM in April specifically notes free expression as an independent basis for action. CDT has been very active on these issues. Tell us how we should think about free expression as we craft these kinds of rules.
Thank you so much, John. That is our primary concern in this proceeding. We are fully aware of the very real concerns, and I'm going to surprise Gus by saying I, too, am concerned about FTC authority, having worked in the Internet space now for several decades and having experienced FTC jurisdiction as a consumer protection agency. But we are concerned about the ability of the end user, of the individual, to experience a full digital life online, and that is both to express themselves but also to receive information in an unfettered and equal way. And so the profound sense of equality and access for the edge provider to, again, grow and thrive as an institution or as an individual should be, I think, the first order of concern. The litigation risk and the inevitable swirl that we experience here in Washington should be last on the list, and there are many, many other factors, including, which hybrid really works, and I have, again, some love and some concern about Pentelis's, but I do think the clarity achieved in a greenfield approach, as Tim describes, the bifurcation of the two services, is attractive. But, so much has been said about free speech online, and it's a truism to say it's the most important vehicle for the individual in the digital age. So I just want to leave you with some quotes from the Supreme Court in the Reno case. The highest protection is deserved for Internet speech. It is the most participatory form of mass speech yet developed. It is available to anyone, anywhere in the world with access, and the Internet provides significant access to all who wish to speak and creates parity among speakers. That, to me, is the fundamental underpinning of this proceeding.
Let me go to another value. Tim, I'm going to ask you another question for you and Gus, and you want to talk about speech as well. But another value, and you and Gus have each addressed in your comments, although I will say not to precisely the same end, is the question of innovation. In other words, how do we encourage innovation? What sources of innovation need the most protection and encouragement? To the extent you want to pick up on Nuala's comment, could you also talk about innovation,
Sure.
and then we'll go to Gus on that point?
Sure, I'd be pleased to. So I want to return to a question which is related, which is why does the FCC exist? It's not a trivial issue, and it, I think, should be re-examined now and then. And the question is, why does it exist when we have antitrust agencies? And when you really think about it, I worked at an antitrust agency. They do a good job. But the main difference is that the FCC is able to, and in theory, is sensitive to non-economic concerns, or economic concerns which the antitrust law has had trouble capturing well. And the big examples of that are free speech, are the sort of values, I guess, non-economic values of things like local news or local television, political concerns, and one that you just mentioned, Saturday morning cartoons, children's issues, all these things which antitrust law struggles with, and also something that antitrust law has always struggled with, which is the value of innovation. So I'll just give some examples. How do you value, or how does, typical economic analysis focused on prices value something like the invention of Skype, which allowed people to call their families in Mexico for cheaper. Actually, it might be, economics might be able to reflect it's very challenging and difficult. Google Maps, an invention like Google Maps, which was invented on the open, neutral internet. People don't get lost, therefore spend less money on taxis. Therefore, in some ways, revenue goes down,
right,
but actually happiness and satisfaction goes up as people are less secure about being lost and so forth. High school reunions, which happened because social networking was invented over the last 10 years, and people are able to see whether they enjoy them or not, or reunite with old family members. These are things that's really hard for a straight-up economic analysis. I mean, fancy economists can try to measure them, but they're very hard. These are all things that have happened on the open internet. These are all innovations from the last 10 years. And so I think the FCC needs to realize that it has the advantage here over the FTC and the Justice Department in being a place that has, first of all, a great track record over the last 10 years with internet innovations, and being able to take into consideration and say there's a lot of non-economic values which are being captured by the innovative process. The track record of the internet in innovation is unparalleled over the last 10 years. If it's not, don't fix it. Many of the deviations from net neutrality, which I suspect Gus will claim are these innovations that are being repressed, are actually, in my view, just schemes that would tax the internet economy and, in fact, get in the way of innovation in favor of existing business models. And so you've done the FCC has done a terrific job and should keep on that tradition and realize how great it's been.
Okay. Gus, innovation?
So innovation, economic and non-economic values, the bottom line, the most important thing for the agency to protect is the consumer. The public interest is about the consumer, not the edge providers, not about the Netflixes of the world. The concern has to be, both from an economic perspective and non-economic perspective, protecting the consumer interest and consumer welfare. So on the innovation front, and I'd also like to say something on the free speech front, first, the internet has been incredibly innovative over its history. It's been incredible. And most of that history has occurred during periods during which there have been no open internet rules in the sense that we're talking about today. There's been the background of the Communications Act, the background of antitrust law. We haven't had, except for very short periods, and it was questionable legal authority, open internet rules. And this innovation, all this great stuff has occurred. On a purely economic front, there are a half dozen well-developed bodies of literature here, multi-sided markets, general-purpose technologies, a literature on openness and innovation, vertical integration. It all consistently comes to one result. And this is why people hate economists as much as lawyers, or more than lawyers maybe. We don't know. It's possible that openness can promote innovation. It's possible that openness can harm innovation. It's a case-by-case situation. Ex-ante prophylactic rules are likely to cause harm. In fact, we can be pretty confident they're going to cause harm. They'll also promote some important values. We're not entirely sure. So we should take a step back and say, we're not going to foreclose these innovative opportunities. We're going to let them happen, and ISPs, we're looking at you. The hammer of Thor will come down on you if you're harming innovation. I'd also like to say on the free speech front, this is an incredibly important area that I think the Commission needs to be very, very careful to police with a great deal of vigor and authority. I think that there's a lot of confusion and misunderstanding about, first, the desirability of non-open principles or violating principles of open internet, of the open internet generally. It's really hard to me to understand how they would actually harm most values of free expression in the United States. But if they do, where they do, the Commission needs to say, son, you're entering a world of pain. If the ISPs are going to get involved there, that is a serious problem, and the Commission should not stand for it.
So, Mark, let me just ask this question.
I'm going to answer that one. So.
You don't know if this one may be better.
Tim Wu's strategy works.
Mark, look, I've known you for a long time, so it's the least surprising thing in the world that the clock tells me you're going to get the last word on this panel. But I just want to come back to one point that Tim talks about non-economic concerns, rightly. There are also economic concerns. You've talked about market power and where that may exist and how that should affect our understanding of open Internet rules. Can you weave that into the answer you had prepared?
Well, I had two, yes. One is, it is factually incorrect to say that there were no open Internet rules. We just didn't call on that. Cartophone, the computer inquiries, and spread spectrum guaranteed people access to bottleneck facilities. Guaranteed, if they behaved in a specific way, power or non-harm to the network, etc. So those were the open access rules. We used to call it open access. Those were the open access rules that gave us the Internet.
But they didn't give us Google, Skype, Facebook.
Absolutely. They gave you Google, Skype, and Facebook because they created a space where people could invent modems. Without Cartophone, we wouldn't have had modems. So every bit that flowed on the Internet for 40 years flowed to devices that were connected because of the Cartophone decision and flowed over a network that was non-discriminatory because of the computer inquiries. So everybody who exists in that space exists because of those decisions. And then, of course, Wi-Fi. Without Wi-Fi, these little devices are crap. Let's be clear. The traffic gets to us on Wi-Fi. Those made this possible. And that's the big picture.
Do we need to go to the indecency rules? or are we going to limit it to open Internet?
So, but the interesting thing is that in the analysis of economics, market power is the least important question. In my comments, the creation of positive externalities in this space, the virtuous circle has a little bit to do about market power, but a lot to do about freedom of experimentation. And so the 706 decision, by embracing the virtuous cycle, gives this agency the ability to escape from the market power question. And in fact, market power has never been a necessary or sufficient condition for common carriage. It was an interesting contribution, but we had all kinds of common carriers that existed in competitive marketplaces throughout history. So market power is not the condition. It's the other stuff that's at least as important. First Amendment, I'll leave that to the First Amendment folks. Economically, positive externalities are more important than market power.
So we're out of time. Let me just thank everybody very much for taking the time to come with us. Thank the audience. Thank for people who submitted questions that informed what Stephanie and I said today. Thanks very much. We will be back at 11:30 for the second panel. Thank you.